So let's talk about this comment. I do get lots of comments like this where people say, well, someone made a will, but they were forced to do something. They were forced to take me out. They really wanted to put me in the will, but my sister or my parents or my brother forced my parents to remove me from the will. And what I would say about that is that wills can be set aside and can be considered not valid or void if the person can be evidenced to have made a will under duress. If you can actually prove that someone made their will because they were forced to do so, because they were pressured to do so, because they were threatened, then that will could be set aside. But in reality, it is very difficult to prove that someone was actually forced to do anything. To prove that someone's been forced to make a will is very difficult. A lot of people go to solicitors to have their wills made. When the solicitor is taking instructions, they usually take instructions without anyone else in the room. Solicitors do a really thorough job to make sure that the instructions that they're getting are independent instructions from someone. And if I have any concerns that someone's being pressured to do something, I won't make the will. And a lot of time, the best evidence that people can produce to say that someone was forced to do so was some conversation that they've had with the now deceased person, where the deceased person told them, oh, I was going to put you in the will, but John Smith didn't want me to, or they got upset, so I didn't. That's not enough. That's not evidence enough to prove that someone was forced to do something that they didn't want to do. Maybe they're just telling you what you wanted to hear. To prove that someone was forced to do something, there needs to be a real threat, or they kind of might be some sort of blackmail thing, like I won't talk to you again if you don't do this, that kind of thing. It's very difficult to have wills set aside because they were made under duress. Very difficult, and I've only seen it a handful of times. The other thing I'd say about this comment is that if you're a grandchild and you've been left out of a will, then you are not eligible to contest unless you lived with your grandparents. Grandchildren are not eligible people under the Succession Act to contest a grandparent's will. So if you've been left out and you haven't lived with your grandparent, you haven't been financially reliant upon them, then even if you could prove that the will was made under duress, that doesn't mean that you would be able to get anything from the estate.